If you want to know how to prove a point, get the jury instructions. And for those who don't know, the jury instruction tells the jury what they need to know in order to find for one side of the case or the other. Y'all get that part?
Okay.
Just get the jury instructions. If you want to find out any question you want to ask, there you go. A to Z. And this thing, there's a lot of this. And I learned this. This is a trick an attorney gave me. Man, you want to know? Just look at the jury instructions. It'll download it for you, but what it'll tell you is if you find that this happened, that this happened, that this happened, this happened. So when you file your complaint, you write down what happened and hopefully the elements meet. That way you're more entitled to whatever you're looking for. Everybody got that?
Got it.
But you always want to know the elements for what your issue is. And you want to make sure that when it comes to whether or not they adequately pled something, you want to know all the rules. And one of the things I think somebody said something earlier, and I said, oh, I did this last week. There's something else now that I looked at it. Y'all remind me to go over the statute, state statute. See that? An attorney for the state's title 4D C2. An attorney for the state's title 4D child support enforcement agency who appears in a family law matter governed by these rules shall file a notice informing the recipient of the title 4D services and other parties to the case that the 4D attorney represents only the Title 4D agency and not the recipient of the services. The notice must state that the 4D attorney may only address issues concerning determination of paternity, establishment, modification, and enforcement of support obligation, and this notice may be incorporated into a pleading motion or other document filed with the court when the attorney first appears. Now, the reason I brought that up because I wanted to let you, they can only do certain things. But what you may want to start looking into is, and write this down. How many substitutes can we put right here? We got Florida, and you can substitute it with how many other names?
58.
God damn, where you coming from? Isn't there only there's more than 50 states? I guess you're gonna say Guam, Puerto Rico,
All
the
those are
Virgin Islands, all every territory. Okay, yeah. Maybe that'll get you to 58. I say definitely 49. But right there. Y'all see that? You see how all I do is ask the Google machine. Does that make sense to everybody?
yeah.
I ask the Google machine when I have a question. And I have other research tools also that I use from time to time because the firm allows me to use it, but I have my own stuff as well. I told everybody about case text, but there you go. Necessary prerequisites to file a child support action in Florida. I have somebody with Pennsylvania. It's how to apply. File a complaint to support in your local county domestic relations. You do not need to use domestic relations officer to give you a form to fill out. Conference will be scheduled. Okay. And on everything. And a question it has to be asked. You got Kansas, Minnesota, Florida, or Florida, Kentucky. Do you all know why I asked this question right here?
Is Arizona in there?
Oh, that's a pretty interesting statement. Look at somebody from Arizona got us. The mere sexual relation between the parties in Texas does not suffice to lend validity to their relationship. Cohabitation means dwelling together. Okay, that's depends what the now that just gives you that line. You find out what the case is about by going through there. But there you go. There's all kinds of stuff. So listen, the point I make to that is in most instances you're there because there was some sort of consensual sex. That doesn't necessarily establish standing to determine that alone would make you owe anybody anything. Does that make sense to you guys?
Mm-hmm. Yes, sir. That 5 to 10 minutes, boy, it's gonna cost you.
You should, hell, might I hope that some good 5 to 10 minutes. But yeah. So in action, this is we hailed that unjustified withdrawal from sexual intercourse by the husband over a period of 10 years constituted cruel and inhumane punishment and awarded the granting of divorce to the wife. Wow, that's interesting. Uh, but I guess we all kind of get the point. If this is the only thing that you're there for, maybe you want to attack the order to make sure that they followed all the necessary guidelines. That's a little bit separate from what I was trying to talk about, but I wanted to bring that up, just in general. Something else I want to talk about, and do this right here before I bring y'all to this. Getting information, man. I don't care what your state is. I'm gonna show you all something.